Hey, it's Kylie with Punks for Progress. This is the next segment in the series of state abortion laws series, where we talk about issues that I've come across reading the laws that have been passed this year in various states relating to abortion and women's rights and women's health. And specifically in this segment, I want to talk about the reporting requirements that have been made laws in some of these states and the implications of that as I read through what's required of reporting and why as it relates to abortion. So here we go. So specifically today we're looking at three states, Louisiana, Arkansas, and Wyoming, but the reporting and registry laws are not specific, or they are specific to these states that I'm going to be talking about, but all the states have different variations of these. So I again want to reiterate that I am not representing every view of every person on the left. I am not a representative of AOC. I'm not a representative of anybody except myself. And so this is me responding to reading the laws that have been passed this year as a woman, having had the experiences I've had with relation to access to women's health and my treatment by members of the opposite sex. So yeah. So as you can tell from the name I use and my other videos, I am a nurse. And so let me tell you my general view about reporting to the state and reporting to the federal level and even a worldwide level about health issues and health incidences. I think it's a good idea. There is a whole field that studies the incidences and trends of disease and prevalence of certain complications. It's epidemiology. So it's very useful if you're using the information the right way to warn the public or to focus an area for treatment or for improvement. So in general, I do approve of reporting, but my three big questions that I need to ask with regards to reporting, especially to a state level or a federal level, would be one, what is the information that you're reporting about me? Two, what's the intent or why are you reporting this information about me? What are you going to use this information for? And three, who has access to this information? Is it going to be public record, my name and address and phone number for whatever disease you're reporting about me? Is it going to be accessible only to a few amount of people? Is my name and name and social security number going to be protected? Especially as that applies to HIPAA laws, right? Health Information Protection, the Health Information Protection Act that protects your health information, right? Regarding any physical ailment or mental ailment, it shouldn't be released to the public. So anyway, so the three big questions I would need to answer before I agree to reporting of information to a state and federal level would be, what is the information? Why are we reporting this? For what intent? And then who's going to have access to this information? So I want to start with Wyoming. I don't have much beef with Wyoming. As we saw on our table, they are still on the Roe v. Wade standard, and but the law that they adjusted and passed this year is really informative and a good introduction to what I'm talking about with reporting and access to information and what kind of information is being reported. So when we look at the Wyoming House Bill 103 that was passed and it has taken effect this summer, they have gone in and revised previous statutes relating to reporting of abortions, and they've actually added some things that I do like. So let me read specifically what I do like. they added, in addition to the requirements provided in subsection A of this section, which we'll get to in just a minute, the form shall not contain the name or the address of the pregnant woman or any other common identifiers, including a social security number, driver's license number, or any other information or identifier that would tend to disclose the identity of the pregnant woman or any other participant other than the reporting physician. What information is being reported, why is it being reported, and who has access to it. This one I like because whoever has access to this information ideally would not know the name of the patient that had the abortion or chose to have the abortion, or any identifying factors that could lead to them being found later on. Let's look at the statute that they're referring to that is the requirement in Wyoming for reporting to the state. That they went in and added this, but it can't be anything like their name or their birth date. So this website is Justia US Law. It's a great website, a good resource, again, to find state statutes, especially the ones with lots of subsections and letters and numbers. You can just Google it and it will show you what they are. So in Wyoming, they're referring to these forms for reporting abortions. So we've got 1, the age of the pregnant woman; 2, the type of procedure performed or prescribed; 3, complications, if any; 4, a summary of the pregnant woman's obstetric history regarding previous pregnancies, abortions, and live births; 5, the length and weight of the aborted fetus or embryo when measurable; 6, type of facility where the abortion is performed, like a hospital, clinic, was it a physician's office, etc. Okay, so this is general information, and within the law, the Wyoming law, the House Bill 103 that we're talking about, they didn't give a specific reason as to why they're reporting this. They did say what they're going to do with it, though. So in House Bill 103, not later than June 30th of each year, the Office of Vital Records Services shall issue a public report providing summary statistics for the previous calendar year compiled from all of the abortion reporting forms from that year submitted in accordance with this section for each of the items listed under that statute. The report shall also include the statistics for all previous calendar years during which this subsection was in effect, adjusted to reflect any additional information from late or corrected reports. The office shall ensure that no information included in the public reports could reasonably lead to the identification of any woman upon whom an abortion was performed, induced, or attempted. The report shall be transmitted to the United States Centers for Disease Control and Prevention and for the National Abortion Surveillance Report. So this was informative definitely for me because other bills in other states did not mention this, but apparently it's across the board. States report to their state board, and then that state board reports to the Center for Disease Control and this National Abortion Surveillance program that goes on, and I guess that's where we get all of our statistics. So I guess that's a little bit as to why for statistical reporting, but later on in this video you'll see my issues with that. What I don't get, and you'll hear me question this throughout the video, obviously abortion is a hot topic, but to report it to the Center for Disease Control, the Center for Disease Control, they have a whole list of like reportable and notifiable diseases. So when salmonella is present in your community, that needs to be reported to them, and they can kind of make public statements about prevalence of diseases and infectious diseases and communicable diseases throughout this United States and worldwide. Now, how abortion relates to that, I really don't get. Again, besides it just being a hot topic, I don't see us reporting to the CDC the number of lap band procedures we have. Maybe they do report that, or the number of gallbladder removal procedures we have. I mean, I feel like hospitals keep their own records with that just for the hell of it, but yeah, I other than it just being a hot issue and they want statistics on it so they can bring it down, is my only reason for thinking that they want these statistics. So next up is Arkansas. Let's talk about Arkansas. Our friends in Arkansas would like you to believe that they're very concerned about complications related to abortion, and they want those reported to the state level and then onto the federal level. Complications related to abortion. So much so that in the bill that they wrote, which is known as the House Bill or Senate Bill 3, now known as Act 620, they list out the complications that are related to abortion. They want to scare us. So it could be, a complication could be shock, uterine perforation, cervical laceration, hemorrhage, aspiration or allergic response, infection, sepsis, or death, or an incomplete abortion, or damage to the uterus, or an infant born alive after an abortion. So these are, again, things that they listed in their text of their bill that is now a law, as far as complications related to abortion. And if any of these happen after an abortion, they want it reported. Okay, now when I hear this, I started to give them the benefit of the doubt. Perhaps they want to keep an eye on abortion facilities and women's health facilities to make sure abortions aren't being performed incorrectly, or there's not a high prevalence of horrible infections after abortions at certain clinics, you know, that they're not using sterile procedures or things like that. However, in that same bill, the damning language that I found was this, that an event associated with a medical procedure performed after a natural miscarriage, spontaneous abortion, or fetal death is not subject to reporting under this section. Now, the surgical procedures that happen and that are required after an elective abortion and after a natural miscarriage to get either that ball of tissue out of your uterus, it's the same procedure. It's either a dilation and a curettage or a dilation and evacuation, a D&C or a D&E, if you've heard those before. They have to dilate your cervix, go in transvaginally, transcervical, up into your uterus, scrape out the tissue and pull it back out. That's basically the procedure. You just got to spread your legs, get that in and out, and yeah, that's a D&C or a D&E, but it is done with mild sedation and under sterile procedure. So Arkansas wants you to believe that they care about complications. However, they only want the statistics on the elective abortions, not if they're they're doing a surgery on your uterus because of a natural miscarriage, a spontaneous abortion, or a fetal death may be related to an anomaly. So that's what leads me to believe that they really don't care about monitoring women's health facilities to make sure that they're using proper techniques and sterile equipment and everything, because they just want the bad statistics on, again, the elective abortions when it's the same procedures being performed on the non-elective abortions or after the miscarriages to get that tissue out. They don't care. They don't want the reports on that. So again, it's just they want the reports. They want the damning statistics so they can bring down abortion is basically it. So what else I want to look at with Arkansas is what do they want reported to the state? And this is much more extensive than what we saw in Wyoming, or at least in the bill that it lists out much more specifics. So let's read through. Arkansas Senate Bill 3, now known as Act 620. They want to know the date of the abortion that caused or may have caused the abortion complication. 2, the type of abortion that caused or may have caused the abortion complication. 3, the gestational age of the fetus. 4, the name and type of healthcare facility in which the abortion was performed. 5, the date the abortion complication was diagnosed or treated. 6, the name and type of any healthcare facility other than the reporting healthcare facility in which the abortion complication was diagnosed or treated. 7, a description of the abortion complication. 8, the patient's year of birth, race, marital status, state of residency, and county of residence. 9, the date of the first day of the patient's last menstrual period that occurred before the date of the abortion that caused or may have caused the abortion complication if known. To me, that's the same as the gestational age, but whatever. The number of previous live births of the patient and the number of previous induced abortions of the patients. That's a whole lot of information that they want. It'd be great if they had a whole book of statistics on trends related to all of this, but the fact that they're only gathering this information on the elective abortions, which require a D&C or a D&E, and not the spontaneous abortions or the miscarriages or the fetal anomalies that cause fetal death that require a D&C and a D&E, they don't want information about that. So again, they just want the damning information about the procedure that they hate. And then Arkansas does tell us what they're going to do with this. As healthcare facility described under subdivision B2 of this section shall electronically submit to the department a report on each abortion complication diagnosed or treated by the healthcare facility not later than the 30th day after the date on which the abortion complication was diagnosed or treated. The department shall develop and publish on the website of the department an annual report that aggregates on the statewide basis each abortion complication reported under this section. So I don't know how many more times I can say it. They just want the damning information about the statistics of the elective abortions, when really a D&C procedure, a D&E procedure, after a fetal anomaly, after a spontaneous miscarriage, is going to carry the same complications, possible complications in this list: shock, uterine perforation, cervical laceration, hemorrhage, and all of those things can happen even when you're getting a colposcopy or anything stuck up your vagina into your uterus. So I don't know why they can't expand it if they're truly interested in complications related to women's health. Make a statistical report relating to these complications as it relates to the instruments, any instrument that enters a woman's body from the underside. But no, they just want to know about the elective abortions. So lastly, I want to look at Louisiana. Louisiana's law this year passed no abortions after 6 weeks. And they passed some laws regarding reporting that I want to talk about. And in their bill that became a law, they did list a reason, I will give them that, as to why they are beefing up their reporting requirements. And here, Louisiana House Bill 484, medical records of Louisiana abortion facility patients have been destroyed in violation of current record retention requirements. These acts of destruction have obstructed investigations of sexual assault involving minors and allegations of illegally performed abortions, and have permanently hindered the rights of victims to pursue or obtain justice. So what Louisiana has done with their reporting requirements is completely upped the ante on it, and to a point where I feel like any women's health facility that previously offered abortion is going to look at these requirements and say, hell no, we're not doing this, and therefore, this isn't worth the effort, which is really unfortunate. So let's look at, first of all, the requirements as to who is in charge of record keeping at these facilities. So the individuals listed in subsection A, which we'll get to in just a minute, and the abortion facility shall have an independent duty to ensure that the custodian of records for the abortion facility where the abortion was performed or induced retains the documents required in subsection A of this section for not less than 7 years for adult patients and not less than 10 years from the age of majority for minor patients. The 10-year period for minors shall begin to run when the patient attains the age of 18. So if a minor gets an abortion, they have to keep those records until that minor turns 28. And in the case of adults getting abortions, they need to keep records for 7 years. Now, who needs to keep the records and who's responsible? Not just the records department, but each physician who performs or induces an abortion, the medical director of the facility where the abortion is performed or induced, the administrator of an abortion facility, each abortion facility of its own, and then each owner of the abortion facility. And in that law, it states if they have a 5% investment in that facility or in that health clinic or in that health system, they are personally responsible and required to keep these records. And I believe that later on reads in the bill that it's punishable per occurrence up to 2 years in prison or $1,000 fine per occurrence. Now, from, again, an administrative kind of see if you're the CEO or if you're contributing and a part owner in a women's facility, and now this responsibility is on you to keep records, it's much more likely they're going to just drop that procedure because of these regulations. So let's look at the reports that are required to be kept by each and every one of these people we just listed. According to Louisiana House Bill 484, 1, the certificate required by that revised statute. I believe that is the second physician that co-signs the necessity of the abortion. 2, if the pregnant woman is an unemancipated minor, one of the following: a notarized consent or a court order requiring that abortion. 3, the consent form required by revised statute, that one. 4, the reports required by revised statute, that one, and we'll go over that in just a minute. The certificate required by that revised statute, the signed certificate form provided for in this revised statute indicating that the woman or minor female acknowledged receipt of information materials concerning psychological impacts, illegal coercion, abuse, and human trafficking. So there's lots of reports that it refers out to its revised statutes for. And I just want to look at one of them and show you, again, under Justia, what I found is required. So Louisiana laws, revised statutes relating to reporting of abortion. 1, an individual abortion report for each abortion performed or induced shall be completed by the attending physician. The report shall be confidential, should not contain the name or address of the woman. The report shall include patient number, name and address of the facility at which the abortion was performed or induced, the date of the abortion, the parish or municipality, if any, in which the pregnant woman resides, age of the pregnant woman. If the pregnant woman is a minor, the notarized that we talked about, race, marital status, number of previous pregnancies, education background, number of living children, number of previous induced abortions, date of last induced abortion, date of live birth, method of contraception at time of conception, if any, date of beginning of last menstrual period, medical condition of the woman at the time of abortion, the RH type of the pregnant woman, a photographic print or image produced as the result of the ultrasound test required by the revised statute. We'll talk about that in a later video of the required ultrasounds prior to abortions. The type of abortion procedure, the reason for abortion, the complication by type, the type of procedure done after the abortion, type of family planning recommended, type of additional counseling given, and the signature of the attending physician. And it goes on to a few other things. There's a lot to report in Louisiana, or at least, they list it out. Maybe the forms in the other states require all these as well. It's just not listed out like it is on this bill that is now a law. But yeah, they're kind of reporting procedures, put a ton of weight on the administration of abortion facilities and women's health facilities to the point where it could easily be dropped as a procedure that they provide at their clinic because of all this extra reporting, which is super unfortunate. All right, thanks for watching, and stay tuned for more as I dig into these laws. Thanks.